Hey everybody, this is Justin, also known as the Wrench Head Attorney. Today I'm out here at the Harbor Courthouse working to help keep people out of jail. Today I want to talk about something that's kind of unique that happens to some people, and it's kind of a way to get a little lucky when it comes to court. And that is, what if you show up and your case isn't filed? Now, you were arrested for something, they gave you a notice that you need to appear at a court on a particular date and time, you show up, you're not on the board, you go talk to the prosecutor and they tell you the case isn't filed. So in this, I want to talk about what that means for you. Now, there's three different situations where this can happen. The first one is if it's just a general no file. So you show up, you talk to the prosecutor, say your case is a no file. Now what this means is the DA hasn't filed your case yet. Now I know what you're thinking, this isn't fair. They told you you had to show up at a specific time. If you didn't show up at that time, they would issue a warrant. And so there's consequences for if you're not there, but there's no consequences for the prosecutor. Well, unfortunately, that is the case. Now, this isn't necessarily bad news, because if a case isn't filed, that means the case isn't going forward at the moment. And the prosecutor only has 1 year if it's a misdemeanor from the date of your arrest, or 3 years if it's a felony to file the case. If they don't do that, then the case can't be filed. The statute of limitations bars that from happening. So if you end up with a no file situation, that's kind of what can happen to you. Second situation is if it's under review. Now what this means is the prosecutor has the case, they're just not sure if they're going to file it. Now this could be because of a couple things. Either A, they're waiting on some more evidence, or they're waiting on some more information to decide whether or not they want to file, or B, they're not sure if it's something they want to do. Like maybe it's a case they don't think they can win, maybe they don't think it's really fair to charge you with it. So they're having other people look at it to determine whether or not they're even going to file the case. Now the statute of limitations remains the same in this instance, so 1 year for misdemeanor, 3 years for felony. The final situation, and this is the one that you really want to hear, is if the case has been rejected. So what this means is the prosecutor has absolutely no intention of ever filing the case. Unfortunately, it's not a complete dismissal. They basically kind of leave it open in the odd chance that for some odd reason they decide to file it in the future, but this is very, very rare. So if you end up with a reject, more than likely they're never going to file the case, but you still have to wait for the statute of limitations to run to know that you're fully in the clear. I hope this information helps you. If you have any questions about law or how things work, you're more than welcome to send me a message. I may answer it here in a video. Also, I hope you don't need me, but if you ever find yourself facing criminal prosecution in the Southern California area, go and hit me up. I can't help you.